announce the Queen and Jogee, Ruddock and the Queen.
Ms Jerry.
May it please your Lordship and your Ladyship, might I introduce everyone first? I appear on behalf of the appellant, Mr Jogee, leading Mr Wagner, Miss Shalene and Mr Laffan, the respondent represented by Mr McGuinness at my far left, leading Mr Atkinson, the appellant in the consolidated appeal, Mr Ruddock, is represented by Mr Knowles to my left and Mr Megan, leading Mr Megan. Responding in the case of Ruddock, Mr Stevens, who for today sits behind us at the far left, leading Mr Pennington Benton. May I also say that the interveners are here and willing to assist should you wish to call upon them. Mr Fitzgibbon sits almost immediately behind me, with leading Miss Gallagher and Miss Cecil. Miss Waddup isn't here, but will be here tomorrow. Mr Maloney apologises on behalf of Joint Enterprise Not Guilty by Association that from here on in I will call Jengba, the intervener. He is not here today, will be here tomorrow, but he leads Mr Bunting, who's holding the fort behind me and to my right.
Thank you.
Perhaps, as is the tradition, may I apologise for some of the paperwork and the housekeeping. Not entirely as I would have wished to have presented it. There is another small bundle to come today, including one more transcript. May I simply say, if your Lordships and your Ladyship bear with us, we will be able to guide you through what does look like a voluminous set of papers, in effect over 500 years of law. Our foundation document is in the core bundle at volume 1, tab 7, and our submissions are in the core bundle volume 1 at tab 9. My timing, I hope, will take us to about lunchtime. We submit, as by way of introduction, that together our two documents, the foundations document, the written submissions, and with these oral submissions today, we will demonstrate to you where the law went wrong, what it was missed, what it should be, and how it can be applied to Mr Jogee's case and any other set of facts. My Lords will have noticed that we have proposed amended certified questions. With your Lordship's leave, I'd rather leave that until later on, if I may.
Yes.
Thank you. The framework of our submissions will be an overview of the law, a short overview of the facts, an overview of the options for the court. We have endeavoured to cover all bases to identify what we say is the right option and why the other options are not the way to go. We will then develop our submissions with reference to a few cases. I do not propose to read out our foundation document, our submissions, or all the cases. We've selected but a few. That
seems very sensible, because I should say, for your benefit and your colleagues, that we have read all the written cases, which are some fairly full going into the cases. So the fact that you don't take us to certain cases to make out certain points or to certain issues, we won't take as a fact you've abandoned them. We just assume that you are going to select the points you want to make.
I'm very grateful. My learned junior, Mr Wagner, will then take short submissions of about 20 minutes on the Article 7 legality and policy issues as a separate section, and then we reach a conclusion where we hope to assist the court with our proposed formulation and a simple three-stage test for directing juries. So if I may, I start with an overview of our submissions on the law. My Lords, we submit that the net cast by joint enterprise is far too wide. The law, incorrectly, we submit, changed to a test of foresight which over-criminalises secondary parties, particularly young men like Mr Jogee. The shift was gradual and the underlying basis of authorisation was simply removed. Largely, this is because contemplation was conflated with authorisation. The net is too wide because the traditional and necessary physical and fault elements are missing. There is in our submission no lower form of subjective culpability other than strict liability, and no lower form of physical contribution at all. We submit that the courts have wrongly allowed parasitic accessorial liability to dominate basic accessorial liability and common purpose. The consequence is that the law is too complex and unclear. The burden of proof has effectively been ignored, and flawed policy has given the prosecution an easy sweep. There is in our submission an appalling lack of precision, netting those who do not have the state of mind and do not act intending to assist or encourage the principal offender. One result was that alternatives such as fundamental difference, innocent agency, withdrawal and so on developed as exceptions to mitigate what we submit is the manifest injustice of parasitic accessorial liability. Fundamentally, it should be for the prosecution to prove culpability, not for the defence to raise it, or a lack of it. This court can, and we submit should, reformulate the law on accessorial liability to ensure that alternative modes of participation are properly reflected, and only those with sufficient connection to a particular crime are convicted of a particular offence. We submit that it is this court's responsibility to resolve the judicially created confusion and foundational failure. To wait for Parliament, we submit, would perpetuate injustice and risks making the common law and potentially this court toothless. All the evidence in our submission from the parliamentary committees, the Law Commission reports, the appeals before today, the academic research, the statistics demonstrate in our submission that this court must address this as an issue of law. In our submission, this is a rare opportunity for this court to simplify, rationalise and re-express the law and practice in accessorial liability.
Yeah.
Our overview on the facts is short. You have detailed submissions for us, and I don't propose to go through the facts in detail. You have an agreed facts and issues document. 3 short, simple points. 1, on a proper analysis, Hersey was the principal, but Amin Jogee had insufficient connection to Hersey's offence, and on the evidence, there was no case to answer on any formulation of accessorial liability, old, current, or proposed. 2, no one suggests here that Hersey was not rightly convicted of murder. These submissions relate to an alleged secondary party. Finally, we invite the court to quash Amin Jogee's conviction for murder, not to replace it with manslaughter or any other offence, and not to order a retrial. My Lords, I now come to an overview of the options.
Thank you.
Firstly, we submit that this court has no option but to sort the law out. It really is a dog's breakfast. The law on parasitic accessorial liability gives rise to frequent appeals, particularly in cases of murder. We submit because it has no coherent justification. We will generally use murder as the paradigm offence when we make our submissions on accessorial liability, but of course it applies to all offences. This appeal, we recognise, is capable of much wider effect than murder, manslaughter, affray or acquittal, which you're considering in Mr Jogee's case. This appeal is capable of correcting the problems which we say were unnecessarily created so recently after the decision in Chan Wing Sue. Primarily, we suggest that there should be a return to the foundational law encapsulated in Johnson and Newden in 1950. And my Lords, we submit that the true test for accessorial liability is this. The true test for accessorial liability is knowledge of the essential matters of that offence or that type of offence, and acts which demonstrate an intention to assist or encourage that offence or that type of offence. My Lords, it bears repeating in our submission. The true test for accessorial liability is knowledge of the essential matters of that offence or that type of offence, and acts which demonstrate an intention to assist or encourage that offence or that type of offence.
Yep.
Such a formulation, we submit, can adapt to individuals assisting each other or cases where there is evidence of a common plan. This does not mean that all cases would have to be revisited. As we set out in our written submissions, most previous cases reached a justifiable conclusion, but by the wrong route. The classic example is the joint knife attack in Chan Wing Sue itself. Even that case, where parasitic accessorial liability took root, shows how parasitic accessorial liability lightened the burden for the prosecution. What is needed in our submission is this reformulation that we have suggested to prevent further miscarriages of justice. This test, which we have suggested, encapsulates our arguments on probability, as the result in this case and others is knew the principal would, or knew there was a common plan to.
May that include a contingent plan?
I'm sorry, I couldn't.
May that include a contingent plan, a conditional plan?
My Lords, in terms of conditional intent, we would submit that the suggestion by Messrs Ormerod and Wilson is not the best solution, in the sense that it works in retrospect to identify conditions, and in any event it still contains foresight. So to search for conditions looking backwards in our submission is not the best solution, if that's the question that you're asking me, to look for conditions that then identify...
We'll use it if we have to.
Can I just
Well, what
ask-
about we'll use it if we have to?
Yeah.
Would that be enough?
Yes, in our submission, that arises from some of the old poaching cases taking on all comers. So the idea of we use it if we have to would demonstrate knowledge of the essential matter that the weapon would be used should they come across the gamekeepers or the householder or a police officer investigating whatever the ongoing crime, as we would suggest the court should approach it.
Are you using knowledge effectively as almost as a synonym for intent?
No.
Because it's easy enough to speak of knowledge when you're talking about whether someone is aware of a past event, and that was the situation in Johnson and Newton, wasn't it? What mattered was whether the solicitor, when he assisted in the sale, knew about the under-the-counter payment,
Yes.
which had previously been made. But when you're talking about a future event, is knowledge really the best
My lords,
expression?
my lords misunderstand the knowledge of essential matters. It's a submission that deals with whatever the particular facts of the particular case are. So do you know that your principal has a possession of a knife?
Yes.
Do you know that there is a excess fee for the purchase of the premises?
Yes.
Do you know that the principal would use such violence, has a propensity?
Well, that's the last one, which is the one that I'm just mildly querying.
Yes.
Does it make sense to speak of knowledge that somebody would do something,
It may,
or are you really using it as a synonym for intended that he should if necessary?
no.
You're not.
In the context of knowledge new would, the best example might be the arguments on propensity. A question of fact might be what a principal would do in those circumstances. So if we talk about the craze, there might well be evidence on the facts that the principal would cut someone up or stab someone if in possession of a knife.
Right.
Perhaps another example might be the Stephen Lawrence murder. We
So
submit
knowledge of propensity.
These are really predictors, aren't there? I mean, there is clearly a difference, is there not, between current surrounding circumstances, which are facts that can be known,
yes.
and things which may or may not happen in the future, which can't be known in the same sense, but can be about which there may be belief, foresight, intent.
My Lord, our submission would be very careful. We ought to be very careful about conflating those three words, that the knowledge of the essential matters does depend on what the particular facts of the case are. So,
I quite agree that belief, foresight and intent are three different things, but I'm simply echoing Lord Hughes's question. One can't just roll up and treat as identical knowledge of present circumstances or past events, which are facts, with state of mind about what is going to happen in the future.
well, in our submission, this is where the courts are conflating the issues, because if one has knowledge of the essential facts of that particular case, if one puts oneself in the position of the secondary party, you know who you're with, you know what they would do, or you know what they've done in the past, I should say. So that might be a context of association. But what one mustn't do is elevate foresight to a mental element. Foresight in the past has been used to identify, for example, the scope of a common plan. So if one has two individuals assisting or encouraging each other, there would be specific factual information in relation to those two specific individuals. If there is evidence of a plan in the past, in the historic cases, and I'll take you to it, foresight was merely a question of what could be foreseen from the common plan or the agreement. It is not a mental element. The mental element, in fact, is intention. You act intending to encourage or participate in that, to assist or encourage that offence or that type of offence.
So in relation to future events, what is the essential thing which has to be, in your language, known? Whether known is the right word to use about the future is another matter, but what is the essential matter of which the defendant has to have cognizance?
Well, that's where one has to deal with the practicalities of a criminal trial. You in our submission cannot come up with a very specific test as to if this is the future event, then that makes every defendant liable. One has to look at what are the circumstances. We see the myriad of different circumstances in the cases that are before you. So, and when I take you through those cases, you will see that a lot of effort has been expended on the level of foresight or the level of probability, where the focus should be in our submission on a definitive test so that knowledge and intention remain questions of fact, but this time for a properly directed jury. The proposal that we make is capable of being flexible to every possible factual scenario, but it does two things. First of all, it returns the actus reus, the act of assisting or encouraging, and secondly, it identifies the true mental element, which is intention.
Yes. Thank you.
Thank you. The next part of my submissions relate to some of the other options, so if I may just deal for a moment, before I take you to the cases that I submit demonstrate that we're right, if I might just reject all the others, I'd be grateful. The alternative is to stay as we are, wedded solely to contemplation and unfocused participation. There are, of course, a number of other options. I hope that this identifies them all. The first is, of course, that we have suggested that this court could alter the possibility to a probability test. And we've set out the arguments for that in our submissions, particularly the paper by Professor McNamara in Australia. I don't propose to read all that out or deal with it. We simply submit that probability is safer than possibility. It is an option available to this court. The burden of proof submissions we make, I've already said, form part of the test that we've proposed. Another option is to find a way to restore authorisation, approval, or the concept of assent. I take all of those words from cases that I'll draw your attention to later. Mm-hmm. So this court could say, well, we'll keep contemplation and foresight as a mental element, but there has to also be some sort of authorisation, approval or assent. We urge this court not to do that. Foresight is not an appropriate mental element. What might flow from that is the suggestion, well, what about recklessness? And if one takes a moment to think about recklessness, I hope this shortly tells you why not. The test would be the secondary party foresees a risk that the principal might commit the crime. The secondary party goes on to unreasonably take the risk of the principal committing the crime. The secondary party then acts intending to assist or encourage the principal's crime. And there the secondary party need not intend that the crime take place, only to assist. Superficially, it sounds good, but it doesn't work for these reasons in our submission. It still relies on risk and therefore will still lead to a discussion on levels of risk. It won't work in practice. It has insufficient focus on what the secondary party must be aware of, foresight of the crime, rather than what we suggest, knowledge of the essential matters. And finally, what we argue for with assisting or encouraging the principal with knowledge of the essential matters. So we suggest that recklessness really is not, recklessly assisting or encouraging something is really not the way to go. The original grounds of appeal, I remind your lordships, were to find a separate test for those on the periphery, a probability test for those on the edge of events. Again, it doesn't take too long to see how that would create some difficulties, but at least it would be a way of preventing the over-criminalisation of youth. We stick to our primary submission. We have given you other examples, France and Germany, in our foundation's document. We also suggest that most other alternatives and options have been tried in Australia, what I call the Australian mess. All of that is set out in our written submissions.
Yep.
It is another reason why this is not a matter for Parliament. There are plenty of examples where certainly Australian parliaments across the Federation have got it in our submission horribly wrong. One option which has been suggested is a test of causation. This, we respectfully submit, is the wrong approach. The wrong by the secondary party is the accessorial activity. Causation is a question relating to the principal's activity. To be an accessory, the secondary party need not necessarily be part of the chain of causation. The real question is whether the secondary party, as an accessory, has sufficient connection to the principal's offence.
Yep.
My lords, Jengba have suggested, following the suggestion of joint venture formulated by Professors Ormerod and Wilson. I've already dealt with it slightly in answering questions, but if I may, it's set out in their paper Simply Harsh to Fairly Simple, which you have. In our submission, sadly, that formulation does not solve the problem. Their proposal, unhelpfully in our submission, perpetuates the myth that parasitic accessorial liability is needed at all. Their version in our submission does not specify any act of encouragement or assistance towards further crimes in a joint venture. Such encouragement or assistance is only required for the first crime in that venture. In our submission, as I said only a moment ago, that is not the best solution, as it wrongly works in retrospect. In addition, when one takes a step back, one sees that their version does still contain foresight in its last configuration. Our submission is that suggestion, whilst we're extremely grateful for all of the Jengba intervention and all of the very, very useful information and assistance that is provided, unfortunately, the proposal simply tinkers around the edges without creating anything new or useful. It is also still not simple. Like parasitic accessorial liability, it is unnecessarily complicated. At the point of the commission of the offence, there may be thousands of possible conditions. But to show one condition that happened to eventuate was the one that the secondary party would have assented to, in our submission is still foresight of a possibility. I deal lastly with perhaps what I might call your lordship's mail on oblique intention. I sometimes have to have a babel fish in my ear for academic language, but I hope this shortly deals with the issue of oblique intention. In our submission, English law very clearly treats oblique intention as a rule of evidence, not a rule of substantive law. What may be virtually certain is evidence from which a jury might infer intention. In our submission, this court has no need to interfere with the law on intention, and reference to oblique intention is not practical or useful. And so it is that we submit that our foundations document and written and oral submissions together demonstrate why these other options are not necessary, where the law went wrong and how it can be safely prepared. Therefore, would like to take your lordships through a few sample cases. I do this against the background of 4 important points. Firstly, the overriding objective is justice, not prosecutorial convenience or judicial reputation. Secondly, the decision this week we submit can be made with the advantage of the academic research, all of the evidence that you had, and the extremely helpful interventions. Thirdly, and perhaps equally important to justice, the law needs to work in practice. And fourthly, in our submission, this court needs to restore balance. At present, we submit there is a sense of desperation to convict the wrong man for the wrong crime and an over-reliance on the jury sorting things out. The failures in our submission in some cases have undermined the public perception of the law generally. To put it simply, there are 4 areas of liability for those who are not principals. The first is easily dispensed with. That is the 2007 Act. This is not a case to which the 2007 Act applies. That appears to be, from the paperwork, agreed by everybody. This is not an inchoate offence. Secondly, whilst the 1861 Act is clearly procedural, in our submission, accessorial liability does flow from basic accessorial liability. That is, individuals assisting and encouraging each other. What we used to call aid, abet, counsel, procure. We now use the phrase, and I've chosen it particularly, assist and encourage. The words assist and encourage require connection to an offence and mental culpability. And my lords, for your note, this is set out in detail in our foundations document between paragraphs 24 and 88. Common purpose in our submission is not a rule. It is a subset of basic accessorial liability. It is better referred to as a common plan or common design. This, in our submission, is a question of evidence, which is not difficult if applied properly. Common purpose has the same physical and fault elements as basic accessorial liability. As I said earlier on, foresight was merely used to find the scope of the plan. It is not a fault element. And again, for the ease of your note, this is set out in detail in paragraphs 89 to 132 of our foundations document.
Yep.
Lastly, I come to parasitic accessorial liability, which we all seem to agree can be set out as follows. The principal and the secondary party or parties embark on crime A. The secondary party or parties contemplate crime B, and on that alone, they're guilty. Parasitic accessorial liability fails to apply personal liability for the ultimate event. It requires, in our submission, little or no proof as the focus is on the outcome. Mere contemplation in our submission is the lowest fault element in criminal law. It has no proper foundation. It was wrongly created and it needs to be expunged. And for the ease of your Lordship's note, paragraphs 133 to 214 of our Foundations document sets that out in detail.
Thank you.
The problems with parasitic accessorial liability I can also summarise before coming to the cases. The major problem in our submission is that it is being used to cover all scenarios. Borrowing from my Lord Hughes, in the case of A, B, C, D, there is no prosecutorial precision. The prosecution are routinely ignoring the need to identify whether a case is a 2007 case, a basic accessorial liability case, a common purpose case, or a parasitic accessorial liability case. Because parasitic accessorial liability is wrongly all-encompassing. Why bother with the rest when you hardly have to prove anything to get a result? In our submission, Mr. Jogee's case, in particular, exposes this consequence. Here, a secondary party has no real connection to the ultimate outcome, either by acts or by mental culpability. The law is appallingly easy for the prosecution. It is reflected in a phrase used by Mr. Stevens responding in the case of Ruddock. For your Lordship's notes, paragraphs 51 and 67 of the Ruddock Respondent's case. They use the phrase, "things might well happen." In our submission, that enters the twilight zone, a frightening non-fiction. In our submission, the prosecution have to prove what happened, not what is suspected. To borrow a phrase from Mr. McGuinness in his submissions, there is already an untenable level of uncertainty. In addition, and importantly, the interventions that you have today demonstrate a disproportionate impact on young, vulnerable, and black and ethnic minority people. It is in our submission, parasitic accessorial liability is in our submission a grossly erroneous tangent of law. Finally, and importantly, dealing with the problems, there is no scope for manslaughter and the line of authority from Anderson and Morris that focused on the evidence. Mr. Stevens, in his response, gives a notional scenario. It's at paragraph 84 of the Ruddock response, which is at page 413 of 437 in the Ruddock's case bundles. Your Lordships will be familiar with the scenario that they produce. Would your Lordships just give me a moment? I was expecting it to be passed to me. Paragraph 84. Thank you very much. So paragraph 84 reads as follows. Take the case, for example, where D2 embarks with D1 on a robbery, intending only to threaten the victim. D2 nevertheless envisages the real possibility, but no more, that D1 might inflict serious harm with intent on the victim. Despite that, he chooses to remain with the enterprise. The victim is killed. Any change in the law, such as is proposed, would result in no liability at all attaching to D2 in respect of the homicide. And so it goes on. The sentence, thank you, the victim is killed, misses out the essential steps, the essential matters. How was the victim killed? What does the secondary party know, or see, or do? Mr. Stevens fails to consider the evidence as required following A, B, C, D in 2011. The actual options need to be reflected at the outset in an indictment: murder, manslaughter, affray, robbery, and so on, not leaving the facts to be sorted out on the imposition of what is described as a disproportionate sentence. My Lords, may I take you to the case of Rahman to identify the crucial question. It's in the bundle of authorities at volume 2, tab 24, and in particular at page B776.
Which page did you say?
B776.
Thank you.
Sorry, what's the electronic?
Electronic? It should be the same. B776 in the authorities bundle. I'm trying to stick to that pagination for you.
Three bundles.
It's three bundles, and it's 776.
Yes.
Which paragraph of the judgment?
76 of the judgment, my Lord Newburger's judgment.
They've got to be elected on criminal law.
Yeah,
Paragraph 76.
it's very good stuff, as far as I can remember.
Yeah.
My Lord, I was just waiting on my Lord Toulson. I wasn't sure.
Right. No, carry on.
Thank you. So paragraph 76.
Yes.
The fundamental issue raised on this appeal can be reduced to the following facts. A and B jointly attack V. B intends to cause V serious injury but not to kill him. B believes that A has the same intention. In the course of the attack, A kills V intending to kill him. And here is the question. Can B avoid conviction for murder by saying that he should not be criminally liable for V being killed as a result of A intending to kill him rather than as a result of A intending seriously to injure him? It goes on. Like many questions of principle, it may not be possible to answer this question in the affirmative or the negative without qualification. Having said that, I believe that in the absence of special circumstances, the answer to the question should be in the negative. In other words, I consider that B should not be able to escape being convicted of murder in such a case, at least in the absence of special circumstances. My Lords, the answer is not negative, the answer is sometimes. If one looks at the question again, can B avoid conviction for murder by saying that he should not be criminally liable for V being killed as a result of A intending to kill him rather than as a result of A intending seriously to injure him? The answer for an accessory is sometimes. It depends on the facts, not special circumstances. What the facts actually are.
Well, hang on a moment. And the first thing to remember is that Rahman takes as read what you've called parasitic accessorial
Yes.
liability, doesn't it? Takes as read Powell and Daniels and Chang Wing Su. So park that for the moment.
Yes.
But you, as I understand it, are addressing this example or scenario as you say, it ought to be.
Yes.
Right. Well, now, if the secondary party, B, participates in the attack with the intention of doing grievous bodily harm, by what route does he cease to be liable for murder?
My Lords, if the example of that type of case is the case of Stringer, I believe, taking part by punching so hard. So there would be direct participation, the knowledge of the essential matters as an accessory, or in fact that defendant being a principal, as was set out in the Lawrence case. So in our submission...
Yes, but if the secondary party helps the principal
Yes.
without himself landing a blow, but helps the principal to attack the victim, and he does it with the intent of causing grievous bodily harm, I'm sorry, the question is...
There would still be liability
the
under...
question is, by what route is he guilty of anything other than murder?
There would still be liability for murder under the proposal that we suggested.
There would?
Yes.
Thank you.
But not in every scenario. That's why we say in our submissions that one has to look at what the facts actually are. Perhaps a better example might be the case of Abel. If I can take your lordships to the case of Abel, that's in volume 3 of the authorities bundle, and it begins at B996. It begins at 995. I have a couple of passages to take you to at B996. So it's volume 3, tab 37.
Thank you.
My Lord, may I simply say this? We're not suggesting that everybody's not guilty of murder, and we're not suggesting that everybody's guilty of murder. What we're suggesting is a formulation that enables the court to adapt. So, my Lords, the case of Abel starts at B995. Yep. Just to remind your Lordships, this was a case that related to an application for a declaration in relation to a booklet setting out ways in which one might commit suicide. Yes. And the question was whether or not the publication of itself of that book would be assisting suicide.
Just before we plunge into the details of this very distinctive case, what's the proposition of law that you're taking from it?
That it demonstrates why there have to be knowledge of the essential matters, what the facts are, why the court has to look at what the facts of a particular case are, because there are some specific passages in the judgment that assist me in that point and make it very clear if the example that I gave you in Rahman is not. If I may start with the head note, I know it's not always the best place to start, but it is rather succinctly put. The application for a declaration was refused, that for supply of the booklet to amount to an offence under section 2.1 of the 1961 Act, the court held that it had to be proved that the supplier, whilst intending the booklet to be used by a person actually contemplating suicide, and with the object of assisting or otherwise encouraging him, supplied the booklet to such a person, who then read it and, except in the case of an attempted offence, was assisted or encouraged by reading it to commit or attempt to commit suicide. That whilst there might be circumstances in which supply of the booklet would undoubtedly amount to an offence, without proof of the necessary intent, it could not be said in advance that any particular supply would be an offence, and that it was for a jury to decide in each case whether the necessary facts had been proved. And if I can take you now to page B1009, which is page 809 of the original report.
Yes.
Just a couple of extracts there, essentially 4 lines.
Yes.
Firstly, at E, as the judge had directed the jury in the case of Bainbridge, which I'll come to later, it must be proved he knew the type of crime which was in fact committed was intended. It's from the judgments that we take the phrase, the crime or the type of crime. And then lower down that page, between G and H, I therefore have come clearly to the conclusion that there could be circumstances in which to supply the booklet could amount to an offence. So the circumstances where the supply of a book amounting to assisting or encouraging suicide were not met by general publication. There had to be something specific, and there has to be both an actus reus and a mens rea. If one then goes to page B1012, about halfway down the page, a line begins, "I therefore conclude." I therefore conclude that to distribute the booklet can be an offence, but before an offence can be established to have been committed, it must at least be proved A, that the alleged offender had the necessary intent, that is, he intended the booklet to be used by someone contemplating suicide and intended that person would be assisted by the booklet's contents or otherwise encouraged to attempt to take or to take his own life. B, that while he still had that intention, he distributed the booklet to such a person who read it. And C, in addition, if an offence under Section 2 is to be proved, that such a person was assisted or encouraged by so reading the booklet to attempt to take or to take his own life. Otherwise, the alleged offender cannot be guilty of anything more than an attempt. And a little further down the page at G, however, in each case it will be for the jury to decide whether the necessary facts are proved.
Well, yes. In the intervening paragraph, Ms. Justice Wolfridge then was made clear that the form of causation that he was speaking about in his subparagraph C, the person was assisted or encouraged, doesn't require but-for causation.
Yes.
In other words, it's a broader concept of causation.
Well, we would submit it is an identification of the facts which the defendant knew or must have known, and then identification of evidence that the defendant intended to assist or encourage that offence or that type of offence. Not any old offence. So it's very, very specific and identifies personal culpability.
It's a classic statement of the principles of aiding and abetting, counselling and procuring without the complication of an antecedent crime, isn't it?
Yes, absolutely. That's what we submit.
What you're dealing with is the case where there is the complication of an antecedent crime.
Well, we submit there isn't.
And you say it doesn't make any difference.
Well, no, we submit there is no antecedent crime.
Yes, I see. Right, yes, I follow.
And we submit that there should never be any antecedent crime. The best explanation is mathematical. You don't have crime A and crime B, you have crime N.
Yes.
And it becomes a more detailed factual scenario that one still has to identify the intention of the secondary party to assist or encourage.
Right.
Classic example being the jemmy that's used to open the door, then being taken inside the house. Courts must stop and identify. What did the secondary party know? At that point, the jemmy is no longer useful for opening a door. What's it for? Assaulting a householder or turning off the electricity.
Yeah, well, that example is normally prayed in aid as an illustration of the principle that in looking at basic accessorial liability, the liability is limited by the scope of the common purpose.
Yes, but you might have a case where two individuals or individuals are assisting or encouraging each other. You might have a case of a common plan. The trial court, the prosecution have to identify what that is. They are both questions of evidence and what can be inferred from the secondary parties, from the facts to identify the secondary party's intention. The mens rea is intention, it's not foresight. The point that I'm really making here is that the crucial question, before one comes to the overview of the cases, is that there must be a test which is capable of adapting to the myriad of factual circumstances which come before the criminal courts.
Yep.
So just to assist the court on the overview of the cases that we're going to take, there are a selection of what we submit are the most fundamentally important authorities.
Could you tell us which they're going to be?
Yes. They come in 4 sections: history, Under history, you will hear of Pridmore, Davies and Smith.
Yeah.
That's Wesley Smith, is it?
Yes,
Yep.
Wesley Smith in 1963.
Yep.
And Davis and the DPP.
I'm sorry, I can't.
Davis and the DPP.
Davis and the
Yep.
DPP in 1954.
Yep.
And Pridmore, yes.
Yep.
Sorry. Next, under the heading conflation of contemplation and authorisation, I will go to Chan Wing Soo, Hu Chin Ming, and Rahman, with passing comment on McAuliffe and Powell and English. I'm not sure I can certainly take you to Powell and English as well if you really need me to. Under the heading,
Well,
I can
we
give you
can-
the paragraphs.
You have faster and slower members of the class. Sorry.
Miss Jogee, if you're going to ask us to reconsider the line of cases which begin with Chang Wing Soo, you cannot avoid confronting Powell and English.
I have the exact paragraphs. What I really meant was I can probably recite them without taking you there. So under the heading, if I can just make myself clear.
Headings, we've got 3 cases, although on history, 3 cases on conflation.
Thank you.
Albeit that it looks as if we may have to look at making
Next
it
heading
more.
will be Anderson and Morris, and that line of authority.
Well, that fits with Wesley, doesn't it? Wesley Smith.
There is some overlap. I'd invite the court just to bear with me.
Right.
Under the Anderson and Morris line of authority, the cases will be Anderson and Morris itself,
Yep,
Lovesey in 1970,
Yeah.
Reed in 1976,
Yeah.
Slack in 1989, Wakely in 1990, and Hyde in 1991. Short references. And the final section will be what I'm calling the Johnson and Uden section. And they will be Johnson and Uden, Bainbridge, Attorney General's reference number 1 of 1975, Gamble, the Northern Irish Gamble in 1989, Maxwell and the DPP of Northern Ireland in 1992, and Mendes in 2010.
yeah. I just, not threateningly, but just bearing in mind you've got to pace yourself, I'd remind you that you have an hour and 25 minutes.
Yes. Very
In
short,
total, yeah.
very
No.
short references.
Yeah, I'm just reminding you, I'm not
Yes, I shall.
seeking to be...
I shall trot rather than gallop or walk. Thank you. If we can, therefore, go to the history and remind ourselves to exercise caution that some of the historical cases, of course, were before the abolition of the murder felony rule.
Yeah.
And before the abolition of the presumption of intention as to natural and probable consequences. But nonetheless, we submit that the history demonstrates the true focus was on identifying culpability as an accessory. So we have selected these from the history simply to show that what the focus of the law was on and should be on is identifying an accessory's culpability. So if I could take your lordships to Pridmore in volume 4 of the authorities.
Yeah,
It begins at 1715 and it's in tab 69.
thank you. Yep. Thank you. Yep.
My lord, it was winter time in Titchmarsh Woods when Pridmore and Ironmonger went out poaching with a sawn-off shotgun
Yep.
and a 3-foot stick. Both were convicted of shooting with intent to murder of the gamekeepers who confronted them. On page B175, one sees not simply the verdict, 1715,
Yeah.
one sees not simply the verdict, but the questions that were asked of
Yes.
the jury. The verdict the jury ultimately returned, they said this: we find both guilty of intent to murder. We are unable to say which of them fired the shot. So we have an unidentified principal case. Mr. Justice Banks then asked, but you are agreed that it was done as a result of the common purpose or intent to offer resistance, even to the extent of firing if there was an attempt at apprehension. The foreman replies, we are agreed that the intention was to prevent arrest at all costs, even to the extent of murder. Mr. Justice Banks, and that both were acting in the common purpose of doing that. The foreman, we are agreed on that. The key point is we submit that the first references to the common purpose cases, in the common purpose cases, to foresight and contemplation, as I've said already, were clearly as a means to identify the scope of the common purpose. They were not a means to add further crimes beyond the common purpose. Can I take your lordships over the page, please?
Yes,
To B1717.
yes.
Just above halfway down the page, there's a section that deals with the summing up. The line begins, think that there had been. Just above that, the sentence begins, that much cannot be questioned. So the direction to the jury was, if you are satisfied that there is evidence that upon which you ought to act, then of course you will find them both guilty and it would not matter which fired the shot. That much cannot be questioned. Or if you think that there had been no previous arrangement between them, but that the nature of the enterprise was such that both must have realised that resistance at all costs was likely to happen, if you are satisfied with that, you would be justified in finding both guilty, although you are not satisfied which fired. So that was the summing up to the jury and the use of the word realised, but in our submission used in the context of identifying the scope of the common purpose, not as the fault element. A little bit further down the page, it reads, Mr. Dyer said we must look at the conduct of the two men as well. That is not necessary that there should have been a formal agreement, but that it may be inferred from their conduct at the time that they went out not merely for poaching, but to escape arrest if possible, and to assist each other to escape. So, qualified or glossed, it is not necessary to criticise the summing up. If not so qualified or glossed, it is not absolutely correct on a broad view. The court is satisfied that the judge did not err in his summing up. And then the important paragraph. Then the point was taken whether there was any evidence to be left to the jury or to justify the finding of a common purpose. It really comes to what was the attitude or what were the gestures of the man with the stick. If having a stick 3 feet 6 inches in length, he faced about on the call of stand back or to see what happened, and if he had his stick in a threatening attitude and in that way supported his comrade, one man showing that he would shoot and the other that he would strike, even if retiring, as he might well do, to give the other man time to fire, the jury might then find that each man showed fight for himself and his comrade, with the weapon he had handy. Though there is not much evidence on the point, there is some, if the gestures supported the suggestion, and therefore the appeal must be dismissed. So foresight to identify the purpose, the scope of the purpose of those two men, Ironmonger and Pridmore, that the use of a gun and the waving of the stick demonstrated that the scope of the plan was to resist all opposers, as the old phrase used to be. Pridmore, we submit, is not authority for foresight as a mental element, but as evidence of the plan. Sometimes the offence is known and agreed and planned, and sometimes the type of offence is known. What matters is what each party knows and does. So another example, I'm not going to take you to it, is Betts and Ridley, the older case of Betts and Ridley in 1931, which was the robbery of the old man taking takings to the bank, and it was found that both the principal and the driver had envisaged that the principal would use whatever violence was necessary in order to obtain the money, and there was really, for Betts, no limitation on the sort of violence that would be used. He, of course, hit the old man on the head, probably with a weapon, but that was not entirely proved. So that brings us then to Davies. Davies is in volume 1 at tab 5. Volume 1. Thank you.
Page.
It begins at page B91. That's not the correct volume. I need the volume of authority. Just my ones are here. Just take that away.
Yep. Yep.
Your Lordships, just give me a moment. I'm just opening the right bundle myself. So Davies, my lords, was a stabbing involving a group of youths on benches at Clapham Common. Davies was convicted as the principal. On the evidence, he was the man with the knife. But the evidence came from alleged accomplices. And the reason Davies is of assistance is because the court does its best, if you like, to identify what an accomplice is. So if I can take your Lordships to page B108, please.
Yep.
Yes, and the complaint was it not, that an accomplice warning ought to have been given in relation to the evidence of one of the youths. And it was in that context that the question arose, what constituted accomplice for the purposes of determining whether the jury needed to be given a warning.
Exactly so. B108 to start with, about halfway down the page, the paragraph begins, "My Lords, I will recur later to certain other features of the trial which appear indirectly relevant, but for the present will proceed to deal with the three problems raised by the main ground of appeal. A, what's the scope and effect of the rule that a judge ought to warn juries in connection with the evidence of an accomplice? B, what is an accomplice within the rule? C, whatever be the answers to these questions, what, if any, is their application to the evidence of the witness Lawson?" And in relation to A, the judgment goes on, "I don't propose to explore the remote historic origins of the rule, nor the doctrine and practice of," and the word approvement. My Lords will have seen the words assent, approval, authorisation. He goes, "If it is clear that an accomplice is and was at all material times a competent witness, and that a conviction based on his evidence, though uncorroborated, could and can be supported." If I can then take you to B114, this reinforces what we submit is identifying the culpability of an accomplice from the evidence. So B114, second paragraph begins, "My Lords, these extensions of the term are embedded in our case law." That paragraph there.
Yes, do you want
And it would not be inconvenient for any authority other than the legislature to disturb them. Neither of them affects this case. Lawson was not a receiver, nor was there any question of system. Lawson, if he was to be an accomplice at all, had to be an accomplice to the crime of murder. I can see no reason for any further extension of the term accomplice. In particular, I can see no reason why, if half a dozen boys fight another crowd and one of them produces a knife and stabs one of the opponents to death, all the rest of his group should be treated as accomplices in the use of the knife and the infliction of mortal injury by that means, unless there is evidence that the rest intended or concerted, or at least contemplated an attack with a knife by one of their number as opposed to a common assault. If all that was designed or envisaged was in fact a common assault, then there was no evidence that Lawson, a party to that common assault, knew that any of his companions had a knife. Then Lawson was not an accomplice in the crime consisting of its felonious use. It should be borne in mind in this connection that all suggestion of a concerted felonious onslaught had, by consent, at the instance of counsel for the defence himself, been expunged from the Crown's case and from the issues put to the jury. It then goes on and deals with defence counsel's approach, but in the next paragraph it goes on, "My Lords, I have tried to define the term accomplice. The branch of the definition relevant to this case is that which covers participes criminis. In respect of the actual crime charged, whether as principals or accessories before or after the fact. But it may reasonably be asked who is to decide or how it is to be decided whether a particular witness was partis criminis in the case in hand. In many or most cases, this question answers itself, or to be more exact, is answered by the witness in question himself, by confessing to participation, by pleading guilty to it, or by being convicted of it. But it is indisputable that there are witnesses outside these straightforward categories, in respect of whom the answer has to be sought elsewhere. The witnesses concerned may never have confessed or may never have been arraigned or put on trial in respect of the crime involved. Such cases fall into two classes. In the first, the judge can properly rule that there is no evidence that the witness was what I will for short call a participant. The present case, in my view, happens to fall within this class and can be decided on that narrow ground. But there are other cases within this field in which there is evidence on which a reasonable jury could find that a witness was a participant.
Yeah. I'm just still getting concerned about time. I see how you rely on what's on 114. Anyway, yes, let's
Thank
move
you.
on.
So the short point being identifying culpability on the evidence,
Yes.
both acts and mental culpability. The final case in this section is the case of Wesley Smith in 1963.
Well, it's interesting, isn't it, in passing, Ms. Jerry, that whilst Lord Simmons was on 114, in effect saying there really wasn't any reason why this particular witness should be treated as an accomplice, unless there's evidence that he intended or concerted or at least contemplated.
Yes.
And we see those words picked up later, don't we? Or at least contemplated.
Yes.
It isn't as if the point had ever been argued in Davis, but they turn up later, do they not?
Yes.
Yeah.
Let's
just keep that in mind as we go on.
Without repeating myself too much, in my submission, those are identified different cases where one is individuals or common plan.
Yes, I follow.
And
But it's just a throwaway line almost. I can see no reason why, unless, and then, or at least contemplated. It's pretty loose.
my lords,
Yeah.
that is the problem, the use of loose language, which is why we've proposed something
Understand?
overarching. The final case in this section is the case of Wesley Smith.
Bundle,
Appears in
page.
Volume 2, tab 26, page 8B826.
Thank you very much. Yep. Yes.
So this was a killing of a barman where the principal stabbed the barman. The secondary party was outside, but the secondary party knew that the principal inside had a knife.
Well, he was also outside throwing bricks at the pub, wasn't he?
He was, and we'll come to that in the section that I've chosen. He was convicted of manslaughter, not murder. And my lords, if I can take you to B832.
Thank you.
Long passages above that are the directions to the jury. Just under halfway up from the bottom, it begins the grounds of appeal in this case.
Yes. Final paragraph. Yep.
Yes.
Yep.
The grounds of appeal in this case, although worded in different ways, really, as I understand them, amount to the same thing. That is, that the use of a knife by Atkinson in this case was a departure, that is to say, assuming against Smith, as must be assumed in the light of the jury's verdict, that he was a party to some concerted action being taken against the barman. He was certainly not a party to the use upon the barman of a knife which resulted in the barman's death. It is significant, as I have shown by reading Smith's own statement, that he knew that Atkinson carried a knife. Indeed, I think he knew that one of the other men carried a cutthroat razor. It must have been clearly within the contemplation of a man like Smith, who, to use one expression, had almost gone berserk himself, to have left the public house only to get bricks to tear up the joint, that if the bartender did his duty to quell the disturbance and picked up the nightstick, anyone whom he knew had a knife in his possession, like Atkinson, might use it on the barman, as Atkinson did. By no stretch of the imagination, in the opinion of this court, can that be said to be outside the scope of the concerted action in this case. So here we see that in our submission, the relevant test is knowledge and intention. The use of the word contemplation is to define the scope of the common purpose, or what is referred to there of the
Well, not to
concerted
define,
action.
but as a pointer towards.
Thank you, yes. I'll try not to use loose language myself. A pointer towards the frame of the plan. And it does reflect the historical use of taking on all opposers. So those cases dealing with identifying culpability. The law, however, now convicts defendants who the prosecution have not shown in our submission to have any responsibility for that crime. How do they do that and why do they do that? Because contemplation has been conflated with authorisation, and effectively the actus reus and the mens rea have been merged. I won't take you to every case. The background is the language of assent used in Johns and the Queen in 1980 and referred to in Chan Wing Soo.
Now, are you going to make any reference to that? Because the Privy Council relied on it quite heavily. Clearly, Sir Robin Cook was strongly influenced by Johns.
Yes, it's rather than take you to the case itself, it's referred to in quite a lot of detail in the other cases. So
Yes. But
we have
I mean, in the wealth of academic literature that you've asked us to look at, there is an argument advanced that if you look at the majority judgment in Johns, the reasoning is rather different from the way in which Sir Robin Cook approached the matter.
yes, we have set that out in our submissions,
Right.
rather a long section in our
Yep.
submissions document at paragraph 63 onwards, dealing with the failure of the case of Hui, that I'll come to later, to recognise the use of assent in Johns. So
Paragraphs which, do you say?
paragraph
63
63 onwards
Sure.
of our written submissions, which is why I wasn't going to take you to the particular case, because we've dealt with it in some detail.
Yes,
So, for your Lordship's note, paragraph 63 and the 4 A, B, C, D
Yep.
available there.
page 328. Okay, yep.
Thank you. I don't
Yep.
propose to read them. I'd like to go straight to Chan Wing Soo, if I may,
May.
which is at volume 1 of the authorities, tab 2, and in particular, page B18.
Yes.
B18, yes.
Thank you.
So the point here being the conflation of contemplation with authorisation. If one goes to G on page 18,
Yes.
just above, the case must depend rather on the wider principle whereby a secondary party is criminally liable for acts by the primary offender of a type which the former foresees but doesn't necessarily intend. That there is such a principle is not in doubt. It turns on contemplation, or putting the same idea in other words, authorisation, which may be expressed but is more usually implied. It meets the case of a crime foreseen as a possible incident of the common unlawful enterprise. The criminal culpability lies in participating in the venture with that foresight. By this time, in 1985, what Sir Robin Cook does not only is to raise foresight to a fault element and ignore intention, but also, remarkably, doesn't use a thesaurus, because contemplation in our submission is very different from authorisation. And those examples flow in other cases I can take you to very shortly. The next I'd like to refer you to is Ho Chin Ming in 1992. That is in the same volume at tab 6,
Thank you.
this time at B132.
Thank you.
I didn't deal with the facts of Chan Wing Soo, it was the 3 robbers with knives all entering the property. I'm sure your lordships are familiar with it. In relation to Chan Wing Soo, the facts were that A went looking for V, the victim, with a water pipe, because his girlfriend said she'd been intimidated by that person. A number of others went with A. He, in fact, assaulted someone else. So the principal was convicted of manslaughter.
They all went off looking for somebody against whom they had a grudge.
Yes.
One of them is armed. He found somebody he thought was the target, and he killed him.
He did, an entirely different person. He was convicted of manslaughter. The secondary party was tried separately and convicted of murder and sentenced to death. That conviction was upheld wrongly in our submission, and wrongly because of the conflation of contemplation and authorisation. The particular passage is page 132.
Yes.
The reason I take you here is because that conflation was created by council. And you can see council's submissions here. Contemplation of both himself and the principal in the first degree as an act which might be done in the course of carrying out the primary criminal intention, an act contemplated as a possible incident of the originally planned particular venture. The crux of that dictum is that the act must be within the contemplation of both parties. For the Crown to establish murder against a secondary party on the basis that he contemplated or authorised an attack with murderous intent, it is necessary to prove that the primary party himself so contemplated. So that conflation created by council is then adopted by Lord Lowry on page B136.
Just hang on a moment. The submission that was being made in Hui Chi Minh is quite important, isn't it? Whose contemplation of grievous bodily harm was counsel for the appellant talking about?
Well, there he seems to be talking about the principal.
Exactly. He never queried Chan Wing Soo, did he?
No.
He said the argument in Hui Chi Minh was whether you'd ever got to the Chan Wing Soo principle unless the principal was shown to have intended either at least grievous bodily harm. Now, in fact, the Crown had proved that.
Yes, and have in most cases.
And that was the end of the submission.
Yes, and have in most cases, so that the first step, of course, is to identify what is the offence of the principal. In any case,
Yeah.
what has the principal done?
Yeah, all right, thank you.
But the point that I make here is the conflation of contemplation with authorisation, and one sees it on page B136. The defendant's second point relies on Sir Robin Cook's use of the word authorisation as a synonym for contemplation in the passage already cited from Chan Wing Soo. Their lordships consider that Sir Robin used this word, and in that regard they do not differ from counsel, to emphasise the fact that mere foresight is not enough. The accessory, in order to be guilty, must have foreseen the relevant offence which the principal may commit as a possible incident of the common unlawful enterprise, and must, with such foresight, still have participated in the enterprise. Just pausing there, that sounds very much like using foresight to identify the scope of the common purpose or plan.
It is, providing it is an incident of the common unlawful enterprise.
Yes.
What he's saying is that mere foresight, absent a common unlawful enterprise, isn't sufficient.
Yes.
Yes.
The problem is the next sentence. The word authorisation explains what is meant by contemplation, but does not add a new ingredient. My lords, we're then left with just contemplation in our submission.
Well,
as-
are you leaving Hui Chi Minh?
Yes.
Well, there's a rather important section on internal pages 51 to 52, B134 to 135. Halfway down B134, court records that Council's submission was based on Johns and the Queen, then identifies what the issue was in Johns and the Queen. It's
Yes.
rather an odd point, whether the same law applied to accessories before the fact as applied to principals in second degree. But in the course of the judgment, Justices Murphy, Mason and Wilson set out the law requiring the act to have been within the contemplation of both the principal and the accessory as an act which might be done in the course of carrying out the primary criminal intention. Now, if one pauses to ask oneself why it is maybe thought to have been relevant that both contemplated as an act which might be done in the course of carrying out the primary intention, the answer which might prompt itself is because that would be relevant in determining what is indeed the common purpose, what they had jointly agreed to do.
Yes.
The judgment goes on to recognise that Johns was relied on by Sir Robin Cook in Chan Wang Su, and then it says that at the top of the next page, in such a case, the contemplation of both parties would be relevant, but, as appears from Sir Robin Cook's judgment, the secondary party may be liable simply by reason of his participating in the joint enterprise with his foresight. And he notes that this is departing in this respect from some of the observations in earlier authorities.
Yes.
And that is really the big step forward, isn't it?
Yes.
Between looking to see what both contemplated in order to identify what was the common purpose, and then, as it's put rather nicely, departing in some respect to looking purely at the foresight of the defendant.
My Lord.
Now so that on this occasion, and Privy Council has identified the change, and that Ho Chi Minh, Chan Wing Su did involve a real development of a law, but goes on to uphold it.
Yes. We cannot ignore the word knows in this passage that your Lordship has just cited, and it's repeated on page B135 about halfway down. Let it be supposed that two men embark on a robbery, one the principal, two the knowledge of the other, the accessory, is carrying a gun. Well,
I mean, that part is plainly right, isn't it?
Yes.
If you've got a conditional intent, i.e. you're carrying guns, you very much hope not to have to use them, but if push comes to shove you will, then whether the likelihood of your having to use them is a probability or less than a probability, a matter which it would be impossible for anybody to evaluate, can't logically or morally affect guilt, can it?
My submission would be it's not impossible to evaluate. What Ho Chi Minh did, it chose to follow Chan Wing Su without considering the practical reality, without separating the physical and the fault elements.
But how can anybody, before the robbery is carried out, know what is the probability that you're going to meet with serious resistance requiring to be met by a gun in riposte?
One example might be the poaching cases where the gamekeepers are out looking for the poachers. There are all sorts of cases where one could know what's going to happen, perhaps because one's done it before. The important point here is that there has to be an element of authorisation, which is the actus reus of acting, intending to assist or encourage. Once you've identified the crime, the plan or common purpose, or the type of crime, the burglary with violence, the robbery with violence, then the mens rea is you act with intention to assist or encourage that crime or that type of crime. The use of contemplation and authorisation has done two things. Firstly, it's lowered the mens rea, and secondly, it's removed the acts.
Well, we know all that. The question
Yes.
is whether it's right or not.
Well, simply, no, it's not.
That's just assertion.
Yes.
What we're trying to see is, isn't it, how it's come about?
Yes, absolutely. I hope I'm assisting in that. The relevant paragraphs in Powell and English are 27E.
Where do we find that?
Well, here we go.
Volume 2, is it?
Would your Lordships give me a moment to check that the actual bundle with the properly paginated document has
We've got some
arrived? Because the one
updated
you have
bundles
in your-
outside.
The one you have in your bundle is a transcript, so I've asked for the proper bundles.
Well, we've got the bundles outside. I hope we could wait till the short adjournment before they were. We would perhaps we. Okay, well, if you give us the tab and the paragraph numbers, and we'll look at the full proper law report in due course.
Powell and English is in volume 2 at tab 23.
Thank you.
It begins at page B728.
Thank you.
At the proper report, the passages that I would read to you are at Lord Steyne at
I see.
13F to 14C.
Beginning with the words. What's the paragraph begin with? No. What's the paragraph begin with? What's the opening words?
I have it set out on an iPad which is about to be given to me in the right position.
See if we can get.
We have,
I'm afraid they arrived after we started tonight.
yes, you only have a transcript. Can I give you the paragraph numbers to start
No,
with?
if you give us a paragraph, what they start with, the words.
Yes,
they
on
start.
page 27E is therefore for the reasons which I have given.
Sorry, whose judgment are you in?
Staying.
No,
No, you're not. at
I'm
23,
not.
you're
I'm in Lord Hutton's now. I'm trying to deal with it in a way just for your note rather than anything for you to look at.
Okay. Well, I think we're going to give up and look at the new.
Yes.
Therefore, for the reasons you'll find at 747. And the passage in Lord Steyne that you're looking for is probably, oh, that's right, 732.
Yeah, it's tab 137, isn't it?
My lords, I think you now have the new bundles that contain
Yeah, we
Powell and English.
Yep,
I
we do.
don't, so I wonder if you bear
Excellent.
with me. I have the two passages on an iPad, and I hope to take you to those.
Right,
May
so-
I start with Lord Hutton at page 27 at E, please? I appreciate it means I'm going to be...
Therefore, for the reasons I've given.
Yes,
Thank you.
Thank you.
Page 3532 of the
thank you very much.
electronic. Yeah, thank you.
Therefore, for the reasons which I have given, I would answer the certified question of law in the appeals of Powell and Daniels and the first certified question in the appeal of English by stating that, subject to the observations which I make in relation to the second certified question in the case of English, it is sufficient to found a conviction for murder for a secondary party to have realised that in the course of the joint enterprise, the primary party might kill with intent to do so or with intent to cause grievous bodily harm.
Right.
Accordingly, I would dismiss the appeals of Powell and Daniels. Now I want page 13, please.
So back 14 pages to page 13.
Yes.
That's Lord Steyne, yes?
Yes.
Thank you. And what do you want us to look at here?
At F, the paragraph that begins, that brings me to
Yep.
the second argument.
If the application, yeah.
If the application of the accessory principle results in a form of constructive liability that would be contrary to principle, and it would be a defect in our criminal law, but subject to a qualification about the definition of the mens rea required for murder, which I will turn later, I would reject the argument that the accessory principle as such imposes a form of constructive liability. The accessory principle requires proof of a subjective state of mind on the part of a participant in a criminal enterprise. That is, foresight that the primary offender might commit a different and more serious offence. He then deals with the explanation from Professor John Smith that how the principle applies in the case of murder. Nevertheless, as the critics point out, it is enough that the accessory is reckless, whereas in the case of the principle, intention must be proved. Recklessness, whether death be caused, is a sufficient mens rea for a principal offender in manslaughter, but not for murder. The accessory to murder, however, must be proved to have been reckless, not merely whether death might be caused, but whether murder might be committed. He must have been aware not merely that death or grievous bodily harm might be caused, but that it might be caused intentionally by a person whom he was assisting or encouraging to commit a crime. Recklessness, whether murder be committed, is different from and more serious than recklessness, whether death be caused by an accident, the court's emphasis. And it goes on, the foresight of the secondary party must be directed to a real possibility of the commission by the primary offender in the course of the criminal enterprise of the greater offence. The liability is imposed because the secondary party is assisting in and encouraging a criminal enterprise which he is aware might result in the commission of a greater offence. The liability of an accessory is predicated on his culpability in respect of the greater offence as defined in law. It is undoubtedly a lesser form of mens rea, but it is unrealistic to say that the accessory principle as such imposes constructive criminal liability. There's a lot more, obviously, in Powell and English, but under this topic of contemplation becoming both the act and the mens rea, those are, we submit, the most relevant passages. May I take you finally to the last case in this section, the case of Rahman at volume 2 of the authorities, page B766. So it's volume 2, tab 24, and then go through to 766, a different page from where you were before. It's paragraph 36 of the original judgment. Deals with, as Sir Robin Cook's explanation, whereby a secondary party is criminally liable for acts by the primary offender of a type which the former foresees but does not necessarily intend, taken from Chanwing 2. And then it reads that there is such a principle is not in doubt. It turns on contemplation, or putting the same idea in other words, authorisation.
Yes, all that's Sir Robin Cook. We've seen it in
Yes.
China.
Yes.
So that in Rahman, when one sees that the judgment contains that section from Sir Robin Cook,
Yeah.
one sees that Rahman adopted, in my submission, that idea of what we have called conflating contemplation with authorisation, but one might better call it raising
Well,
contemplation.
there wasn't any argument about it in Rahman.
No.
The question in Rahman was whether the principle's intent to kill,
Yes.
as distinct from intent to do grievous bodily harm, itself constituted a departure from the common purpose.
Well, my lord, there wasn't any argument in most of these cases about the principles that we are inviting the court to reconsider, which is why we say this court has the opportunity
Quite.
to reformulate, revisit and re-express.
Yep.
My lords, I hope to canter through the next section, although there are a large number of authorities. Can I start with Anderson and Morris? Here, the theme is this, that all of these cases largely involve Geoffrey Lane.
Lord Justice.
And all of these cases, in my submission, deal with participation as a question of fact and common sense for the jury. What I would like to call the steady hand of the Midland Circuit. In saying that,
You're the former Lord Chief Justice.
we do not suggest that Anderson and Morris is the whole of the answer.
Yeah.
But what all of the cases in this line of authority do is attempt to stick to identifying the evidence that demonstrates the state of mind and the intention of the secondary party. So Anderson and Morris itself appears in volume 2 at tab 15.
Thank you. Yep.
My lords will remember this is a stabbing in Nottingham in the street. The principal, Anderson, was convicted of murder. The secondary party, Morris, was convicted of manslaughter.
I think we have it back to front in our bundle, but never mind. It's
I do
576.
apologise.
No, it's all right, provided we know that.
576?
It's 576. I have it back to front. It doesn't matter. Just comment so nobody is taken by surprise.
My
Yep.
lord, I'm very grateful. It does matter, and I do apologise.
No,
once
anyway,
again.
don't worry. Yep.
So, the principal convicted of murder, the secondary party, Morris, of manslaughter. Morris had fought with the victim earlier on and was present at the assault on the victim by the principal later. Ultimately, the evidence from one Christopher was not thought to be sufficiently reliable, so the case proceeds on the basis that Morris did not know that Anderson had a knife or that he was using a knife, and there was evidence that when asked to participate, Morris had refused. So one has to read Anderson and Morris against that background. My lords, important because there Geoffrey Lane, Queen's Counsel, was leading John Machin in this particular case, and of course Lord Lane figures in the following cases, if I can take your lordships to page 584.
Thank you.
Now, for your lordship's note on retirement, I would submit that your lordships should read that page and the following 2 pages at least. Obviously, I'm not going to read 3 pages to you. But at the bottom of page 118 is the submissions made by Mr. Lane on behalf of Morris. It deals with the directions earlier on and how he puts the principle of law. It reads, he would put the principle of law to be invoked in this form, that where 2 persons embark on a joint enterprise, each is liable for the acts done in pursuance of that joint enterprise. That includes liability for unusual consequences if they arise from the execution of the agreed joint enterprise. But, and this is the crux of the matter, that if one of the adventurers goes beyond what has been tacitly agreed as part of the common enterprise, his co-adventurer is not liable for the consequences of that unauthorised act. Finally, he says it is for the jury in every case to decide whether what was done was part of the joint enterprise or went beyond it and was in fact authorised by that joint enterprise. A little bit further down on page 585, as we now are, the line begins, the general principle which Mr. Lane invokes in the present case deals with the case of Wesley. The co-adventurer who in fact killed was known by the defendant to have a knife. It was clear on the facts of that case that the common design involved an attack on a man, in that case a barman, in which the use of a knife would not be outside the scope of the concerted action. And then over the page on B586, it reads, it seems to this court that to say that adventurers are guilty of manslaughter when one of them has departed completely from the concerted action of the common design and has suddenly formed an intent to kill and has used a weapon and acted in a way which no party to that common design could suspect is something which would revolt the conscience of people today. My lords, that is where we are, in fact, at, as far as joint enterprise is concerned. Further down the page, about 6 or 7 lines down, it reads as follows. The law, of course, is not completely logical, but there is nothing really illogical in such a result, in that it could well be said as a matter of common sense that in the latter circumstances the death resulted or was caused by the sudden action of the adventurer who decided to kill and killed. Considered as a matter of causation, there may well be an overwhelming supervening event which is of such a character that it will relegate into history matters which would otherwise be looked upon as causative factors. Looked in that way, there's really nothing illogical in the result to which Mr. Caulfield points. My lords, if one for a moment pauses, what that case appears to be saying is, well, whether or not this was part of what they had agreed or tacitly agreed, if this was the type of the crime or the type of crime, it's a question of fact and common sense for the jury, based on the evidence. That's a very short way of looking at Anderson and Morris. One of the other examples, without taking you to the particular volumes, are Lovesey. Lovesey in 1970 was a jewellery robbery where the principal was not identified, and the court clearly states that the common plan could not be inferred beyond robbery. There simply wasn't the evidence to say what the common plan was beyond robbery, and therefore the convictions for murder were quashed. So it follows that theme of what is the evidence? What's the evidence of a common plan? What's the evidence that one individual knew about the other and the circumstances? Another example is Reed, my lords, in 1976. That was the shooting of the colonel, where the defendants went to the home of the colonel and the colonel was indeed shot. The issue, very convoluted evidence and lots of alleged lies, essentially was this. Did they all go as a team? Or was the particular appellant, Reed, as he described himself, as a stupid observer? That particular appellant was convicted of manslaughter, and the court said, well, the jury must have rejected both of those. He's not part of the team, he's not a stupid observer, therefore the jury have used their common sense to reach manslaughter. And this is an example of where we submit, whilst extremely sensible, in searching for a In some cases, there is a search for a bright line test, and in other cases like these, there is a search for, can you work out from the verdict what the facts were and why the result was? Neither, we submit, are the way to go. The next case that I take...
This was Lord Justice Lawton, future Lord Chief Justice, Lord Justice Lane, who'd been counsel at Anderson Morris, and then Mr. Justice Robert Gough, who later was to preside in Powell and English.
Yes.
But the way in which the court interpreted Anderson Morris and the approach laid down by the court in Reed is of some relevance, is it not?
Yes, the simple way of putting it is that just focusing on what the facts are is not enough. That would be my submission.
Well, they had relevant things to say about manslaughter as well as murder. Yes. But anyway, we're conscious of the case.
Yes. I simply say this, that there is a line of authority that deals with common sense and the practicality. When I started my submissions, this court today needs to find both law and fact, a way in which it can work. The system for accessories can work in a practical way for future cases. Can I take you now to Slack, please, in 1989, which is in volume 4, tab 74. Again.
Page.
Volume 4, tab 74, B1768. It starts, and then I will refer to B1776. By this time, Lord Lane was the Chief Justice, so we've seen him as Queen's Counsel, Mr. Justice Lane, and now as the Lord Chief Justice. This particular case was argued by Stephen Coward as against Brian Escott Cox and Michael Fowler. It's sometimes helpful to see the personnel involved because it's perhaps no surprise that the first people who try to run the Chan Wing Sue point are members of my chambers, but are well known for prosecuting, and Mr. Coward, of course, for defending. I know Michael Fowler, unwell, is probably watching me on the television, so I apologise to him for that. But in my submission, this was a case where the prosecution were trying to run the contemplation point, and Mr. Coward was trying to prevent that happening. This is what one might call the classic burglarious intrusion, as I understand the academics are keen on calling it. It was a burglary of an old lady, an extremely violent burglary where she was cut up, there is no other way of putting it, in an appalling way. And the real question was, what was the level of agreement of the plan? Was it a plan to rob? Slack was the lookout, but he went in when he heard a shout, "She's down." The prosecution submissions are set out on page B1771. And in relation to the evidence that her throat was cut at least 5 times, the prosecution submitted that the appellant couldn't have failed to have seen these terrible injuries, at least as he left the flat, and the fact that the two men remained together until Buick was arrested hours later was hard to explain, except on the basis that the appellant had been party to the murder. The written directions are set out on page B1772. And Mr. Coward's submissions are set out at paragraph E. It is to the second question that objection is taken on the ground that it wrongly equates foresight and contemplation with intent. The directions submits Mr. Coward should have been to this effect: assuming that Buick murdered Mrs. Crowder, has it been proved to the requisite extent that A, at the time of the killing, Buick and the appellant were taking part in a joint enterprise, and B, the appellant intended that Mrs. Crowder be killed or caused really serious harm should the necessity arise. So the argument here is that the accessory has to have the same intent as the principal. We don't submit that. We say the accessory must act intending to assist or encourage the crime or the type of crime of the principal. But what's important here is the effort to run foresight and contemplation by the prosecution and the effort to identify that the mens rea is intention by Mr. Coward. The result is seen over the page at B1774, where the Lord Chief Justice attempts to reconcile Sir Robin Cook with the case of Ward, which had come earlier in 1986. And here in my submission, he is still wedded to the idea that foresight really is identifying the scope of the plan. It reads, if, however, as part of their joint plan, it was understood between them expressly or tacitly that if necessary, one of them would kill or do serious harm as part of their common enterprise, then B is guilty of murder. As appears from the cases we have cited, the direction may be in a variety of forms, provided that it is made clear to the jury that B, to be guilty, must be proved to have lent himself to a criminal enterprise involving the infliction, if necessary, of serious harm or death. At the bottom,
that's the conditional intent, or he's saying it's got to be within the scope of their joint purpose that, if necessary, violence involving infliction of serious harm or death will be used.
Well, we would submit it's not conditional intent. It's the foundational facts of the what they're doing.
Yes, well, you may. We understand your submission. You may submit what you wish, but we're just looking to see what the court on that occasion said the jury had to be told, aren't we?
Yes. At the bottom of the page, it's perhaps helpful that the Lord Chief Justice then goes back to what Sir Robin Cook says, reading, no one formula is exclusively preferable. Indeed, it may be advantageous in a summing up to use more than one, for the question is not one of semantics. But the point here in my submission is that the court is looking at the facts after the event and saying, well, look, this was just so horrible that they must have both been there. It must have been part of what they were both doing. The accessory must have acted intending to assist or encourage. And certainly he stayed together. You can infer that from the fact that they stayed together. And therefore it must be, to use the words in the judgment which now appear on 1776, the question made it clear to the jury that the appellant must have at least tacitly agreed that, if necessary, serious harm should be done to Mrs. Crowder. So this is an example of where we are working backwards, as conditional intention would require you to do, but as the cases were doing, working backwards to work out, well, were they both there? Is it so horrible that one can infer knowledge and intention?
But trace back into history, go back into the 18th century cases, juries were told one day that they would have to consider whether there was an intention to use force to repel any interference. This point that if people go stealing but armed with weapons, the question arises, was it part of the plan, if necessary, to use force, including force causing really serious harm, to prevent interference? It is not a creation of the Court of Appeal in 1989.
No, of course not.
No.
And I've said that earlier on when we were dealing with the poaching cases. But this part of my submissions is identifying where the courts are working backwards on the facts. That's all I'm saying here.
Well, in a sense, you're always working backwards on the facts, because the jury is looking at evidence to decide what was the common purpose or what was the state of mind or whatever.
Yes. Well,
you're addressing us on what is it of which the jury has to be sure.
Not
and,
quite.
And what should it be
at this
of which the jury needs to be sure?
At this stage, I'm identifying that what the courts were doing, the appeal courts were doing, were looking at the facts and working backwards for common sense and practicality. That the test remains intention, not foresight. That the words tacit agreement do not create a new mens rea or a new actus reus. That the agreement may well be an agreement to cause serious harm. The best example I can give, Your Lordship, to make sure that cases involving common purpose or common plans are not proceeded with in future without limitation, which is what we have here, is the case of Gamble. If we think about the kneecapping and the throat cutting in the case of Gamble, which I will come to in a moment, that follows the line of authority in my submission from Johnson and Uden. The clear express plan was not to kill. And one depends there to find that agreement or tacit agreement on the actual evidence. So what...
Well, it's always a matter of evidence, isn't it?
It is.
It's just as it's always a matter of looking backwards, because trials come afterwards. But is the problem this? What is meant by, in this particular extract that you've given us, tacit agreement? Yeah. Is tacit agreement established merely by foresight or only by plan? And, in fact, is plan not another word for intent?
My submission is that if one retains foresight at all, it would be only as a question of fact as to what was the scope of the plan. I appreciate Your Lordship's...
Question of evidence, do you mean?
Yes.
Yes, I see.
But one can't have decisions as questions of fact and common sense without some principle of law.
Right.
And if we stand carefully that principles of law have to identify culpability and the elements of criminal offences have to have an actus reus and a mens rea, the mens rea is intention, it is not contemplation. Yeah. And intention is inferred from all the circumstances. Wakeley is another example in 1990 of where the court decided the outcome on what we would submit was obvious evidence. That's also in volume 4 at tab 76.
Thank you.
Page.
B1780.
What's the next case?
Yep.
That was a case where the principal crushed the victim's skull with a pickaxe handle. All of them went to burgle together. All of them knew that he had the pickaxe handle. And importantly, all of them knew he would use it if disturbed on the burglary. When one reads the facts, that's the evidence. Not only that he had the pickaxe handle, but he would use it. And in those circumstances, at the bottom of page 1780, where you are, we can see the prosecution case. Holly had been the person who inflicted the blows on Mr. Holland with a pickaxe handle. The other two who were parties to the attack, and they had been responsible, just as Holly, for the murder of the old man, because they were willing participants in this enterprise involving serious violence. The evidence is over the page at 1781, 1, 2, 3, 4, 5 paragraphs down. In the middle, Holly brought in a pickaxe handle, which he said he would use if anyone turned up.
Yep.
And at the top of page 3, B1782, the paragraph there, the last 3 lines.
You say this was rightly decided on those facts?
Yes, absolutely.
Thank you.
What
But what the court is really doing is, this is perhaps repetitious, but working backwards. It's obvious from these, I'm sorry to use that phrase.
No, but the point is that it's that sentence you've identified. I don't want to spend too much time on this because you and Mr. Wagner have another 25 minutes, but
yes.
The point is that that's the vital fact.
Yes.
Yep.
The analysis, we can just very quickly note, is that the Lord Chief of the day notes that different summings up have been given in cases of this kind, he expresses the view that this was supposed all to have been made clear in Slack, foot of B 1781. He then comes to the summing up in the case. Part of it was defective because towards halfway down the page, it talks about mere contemplation by the defendant rather than concert, but concludes that on the particular facts of that case, the verdict was inevitable in any event, ergo no miscarriage. But as the point of principle that one can derive was that at that stage, that court thought that the Slack direction was the direction which the law required.
Yes.
Now then, I think Sir John Smith wrote a note on this case, which I don't think we've got in the authorities bundle, but it then comes to be looked at in the House of Lords, where they pick up Lord Lane's parting comment and say effectively there was no practical difference between the two.
Yes, well, that comes really from Hyde in 1991.
Yes, Lord Lane went back to it in Hyde after the Smith article, didn't he?
Yes, he tries to reconcile Chan Wing Soo and Wakeley.
So what we've got is you say, is Slack, Wakeley, Hyde,
Yes.
all examples of the Lord Chief Justice of the day wrestling with the difficulty of reconciling Chan Wing Soo with principle and with some other decisions.
Yes, and if you look at the end of Hyde, I won't take you to it, but there's a passing comment. He says it really would have been much simpler if they've used Anderson and Morris. So he perhaps expressing his frustration. So that line of authority we submit is reflected in Your Lordship, Lord Hughes's own judgment in ABCD, where you express the
Well,
need...
we're a long way down the line by then, and we're all bound by Powell and English.
Well, Your Lordship makes it plain that there is a requirement to focus on the evidence. And in that case, the murder by the principal could not be proved, and Your Lordship quashed the conviction. So we would submit that is a line of authority, but leaving it to the jury is only part of the answer. Leaving it to the jury to make a decision on the facts is right, but we still need a test for accessorial liability that creates a frame to ensure that verdicts have sound foundation, both fact and law. I appreciate I'm overrunning, but we now come to the line of...
You will have to stop at 1 o'clock.
Yes. Well, I would like to take you very briefly to the cases of Johnson and Uden, simply to make one short submission before my learned friend Mr Wagner stands, and he can be shorter. Johnson and Uden, we submit, is a line of reasoning that has been lost. It was not openly considered in Powell and English. It's for these reasons we suggest there can be a reformulation. The test, knowledge of essential matters, we submit has that foundation in law and fact and can adapt to individuals assisting each other. The Bainbridge test, the three-stage Bainbridge test that your lordships can find at B588, Volume 2, Tab 16, is extremely helpful. So, if I move forward to what I was going to say about that later on, Volume 2, Tab 16.
Could you give the page reference again?
Yes,
sorry.
of course. Bainbridge, Volume 2, Tab 16, B588.
Thank you.
It's an extremely short judgment, which I would invite the court to read in full. The three-stage test is on B591, about halfway down the page. This is the cutting equipment case where the question is whether or not the accessory knows the type of crime or has to know the exact crime. The direction to the jury to prove that the prosecution have to prove these matters, first of all, they have to prove the felony itself was committed. Of that there is no doubt. That is not contested. Secondly, they have to prove the defendant, this man Bainbridge, knew that a felony of that kind was intended and was going to be committed, and with that knowledge, he did something to help the felons commit the crime. The knowledge that is required to be proved in the mind of this man Bainbridge is not the knowledge of the precise crime. In other words, it need not be proved he knew the Midland Bank Stoke Newington branch was going to be broken and entered and money stolen from that particular bank, but he must know the type of crime that was in fact committed. And then 4 lines below, it is not enough to show that he either suspected or knew that some crime was going to be committed, some crime which might have been a breaking and entering or might have been disposing of stolen property or anything of that kind. That is not enough. It must be proved he knew the type of crime which was in fact committed was intended. And my lords, the line of authority from Johnson and Newden is Johnson and Newden, the essential matters were the knowledge of the excessive fee. 2 solicitors acquitted because they didn't know. The solicitor convicted as an accessory, the appeal by way of case stated dismissed because he did know. Bainbridge knew the type of crime. In the Attorney General's reference number 1 of 1975, the accessory knew that the driver would drive, having laced the drinks. So he knew that the driver would drive and would drive over the limit. In Gamble, the evidence was that they knew there would be a kneecapping, but the court found that some had acted intending to help a wounding, but not intending to help murder, so identifying the mens rea as intention. There's an extremely important passage in Maxwell from Lord Scarman in relation to the driver of the pub bombing. The knowledge of the type of crime was clearly known by the driver. And similarly, in Mendes, we submit the decision in Mendes is searching or clutching or grasping or almost there. There we have 2 youths of a group, aged 15 and 17. The alternate basis for murder was correctly left, it was found. So originally, the case was put on the basis that one was a principal and one was an accessory. The judge then decided to leave joint enterprise. The consequence was that the verdict could only be identified if the apparent principal was a joint accessory. So the convictions of both of them were quashed and violent disorder was substituted because it depended on the provable knowledge. The jury could not be sure of the Crown's case. We submit that Mendes is one of those cases that arises from poor law and that what needs to occur is the identification of the type of offence. And my lords, in Mendes, the identification of the type of offence can be seen in paragraph 47 of that judgment. It's the last one I take you to before Mr. Wagner speaks. And then I do have a short conclusion after he finishes. So volume 2, tab 21, please.
Okay. Yep,
Paragraph 47 is at page B696.
thank you.
Dealing with the proposition at paragraph 45, dealing with Rahman, the court says it's sound in principle and consistent with Powell and English and Rahman, but then goes on, it would not be just that the defendant should be found guilty of murder of V by P if P's act was a different kind from and much more dangerous than the sorts of acts which the defendant intended or foresaw as part of the joint enterprise. And we submit that's perhaps unwittingly a return to the type of crime that was being spoken about in Bainbridge. The 3-stage test in Bainbridge is what we suggest should happen, and I'll come to the conclusion after my learned friend Mr. Wagner has made short submissions on Article 7 and policy.
Thank you very much, Ms. Garriott. Mr. Wagner.
Thank you, your lordships and your ladyship. I'll try and be very brief. Our submissions are set out.
They're fairly fully set out on Article 7.
Exactly. So I'll give you a broad roadmap.
Thank you.
In essence, the principle of legality and Article 7 are essential to the rule of law. And the reason they're important in this case is because they shift the focus away from the point of conviction when we ask, is parasitic accessorial liability legally sound, to the point of commission where we ask, is the law sufficiently clear and foreseeable? And that means the focus is on the individual citizen.
Yep.
The question is whether the law is sufficiently clear and foreseeable so that we, the citizens, may have, at the point of commission, knowledge of whether what we're about to do is a criminal offence, and regulate our behaviour accordingly. And of course, all that's required is sufficient certainty, not absolute certainty, and that's absolutely clear from the case law. But we say that parasitic accessorial liability is legally incoherent, factually counterintuitive, and practically arbitrary. And for those reasons, it breaches the principle of legality. My learned leader said that this is the law is a dog's breakfast. I paraphrase Jeremy Bentham to say the parasitic accessorial liability is a dog law, which means punishment first, explanation later. I say two things in my submissions. First of all, that parasitic accessorial liability offends the principle of legality because it's insufficiently clear and foreseeable. And second of all, the policy arguments which are advanced in some detail by both respondents are in my submission wholly unevidenced. It will be dangerous for the court to take any account of them whatsoever. So the starting point is R and Rimington. And I think it's the only authority which I must take you to, because the summary is there. It's in Volume 2 of the Authorities Bundle, tab 25.
Thank you.
It starts at 783, and I want to start at page B805. And this is Lord Bingham. This was a case about two defendants, one who had sent his friend shortly after the September the 11th terror attacks, an envelope containing money for a debt and some salt. And he was a butcher, and the salt was a reference to the age of the debt, but it was thought in the sorting office to be anthrax. And the other case was about someone who had made hundreds of abusive phone calls.
Yeah.
And the question was whether it was public nuisance. It was found on the facts in both cases that it wasn't public nuisance. So in fact, the Article 7 argument was slightly periphery. But at paragraph 33 to 35, Lord Bingham sets out the law. He quotes from Jeremy Bentham at 33, "It is the judges, as we have seen, that make the common law. Do you know how they make it? Just as a man makes laws for his dog. When your dog does anything you want to break him of, you wait till he does it, and then you beat him for it. This is the way you make laws for your dog, and this is the way the judges make law for you and me. They won't tell a man beforehand what it is he should not do. They won't so much as allow of his being told. They lie by until he has done something for which they say he should not have done, and then they hang him for it." And then Lord Bingham says, "The domestic law in England and Wales has set its face firmly against dog law."
Yes.
The two other points that are important is at 34, so this is at B809. Lord Bingham says that the common law principles are entirely consistent with Article 7.1 of the European Convention.
Yes.
And then at 35, he lays out a very succinct and useful summary of the basic principles.
Thank you.
And I won't take you through them, but you have it for your notes. I only want to add one point to Lord Bingham's summary,
Yes.
which arises from the Strasbourg case law.
Yes.
And that's the question of whether a law is sufficiently clear and certain depends on the content of the instrument in issue, the field it's designed to cover, and the number and status of those to whom it's addressed. Put another way, context is crucial in assessing the level of certainty and foreseeability that's required. I'll give you two references to that I won't take you to, but that paragraph is expressed in exactly the same terms in Cantonian France, which is volume 5, tab 83, page B1955, paragraph 35, and Kononov and Latvia, also volume 5, tab 86, B2022, paragraph 235. So that's the point that I add is context is important, and in parasitic accessory liability, it's particularly important. So moving on to my submissions on foreseeability, to a large extent, I rely on my submissions are parasitic, if I may coin that phrase, on my learned leaders, in the sense that the law is incoherent. It has taken a number of missteps over the last decades, and that means that the judiciary have found it very difficult to justify the application of it in particular cases. And of course, incoherence will inevitably lead to uncertainty. And I don't put it in any detail, but particularly the concept is unfocused at three levels. First of all, what is participation? Is mere presence enough? What does it mean to participate in a crime? Two, what is foresight? It's been described in a variety of different ways. Mere foresight, contemplation, we say really it amounts to nothing more than a suspicion. And three, what is withdrawal? What does it mean to withdraw from something that you don't know is happening? What does it mean to withdraw from a common purpose which isn't clear?
Yep. Thank you.
And for that reason, lawyers have found it particularly difficult to explain and justify. It's been the subject of consistent appeals to the Court of Appeal, even since Powell and English and Rahman supposedly clarified the law. We still have around 15 appeals to the Court of Appeal, and it clearly troubles the courts.
Yes.
The flip side of that coin is that the prosecutors understand it all too well and know that it provides them with a very useful dragnet in cases involving more than one party, and that's why it's being used so much. But as my learned leader put it, there's an appalling lack of precision arising from the cases. The so-called safeguards are not safe and don't guard anyone, and they lead to arbitrariness. And again, I list without going into detail, these are dealt with particularly in our foundations documents.
Paragraphs. They will let us know later.
I'll provide that if
Fine,
I may.
thank you. Thank you.
121 to 207.
Thank you. Thank you. Yep.
Juries don't understand foresight. Fundamental difference is an extremely difficult concept. What does it, and this leads to the discussions in the more recent cases about what's the difference between particular weapons. Can weapons be inherently more dangerous than other weapons, etc.?
Yep.
The authorities, so not just the lawyers, but the authorities don't understand it. And I'll give you the reference from the Jengba submissions, Core Volume 2, Tab 12, page A473, paragraph 42. And this was a letter sent very recently from police to the young people in Tower Hamlets, apparently thousands of them. Quote, "You may be convicted of a crime and sent to prison for just being present when a serious crime is committed, or being with those persons who commit a crime and you don't try to stop it." So what the police are saying there is your mere presence or your preventing or deciding not to stop a crime happening might lead you into conviction. Of course, that is legally wrong, but it's unsurprising that the police are finding it very difficult to explain to young people exactly what this doctrine means.
Yes.
And that leads me on to the final point on this, which is no surprise, therefore, if the lawyers and the authorities are finding it difficult to explain that the young people, and it is predominantly young people, who are subject to this law, cannot understand it either.
Yes.
Now, I referred earlier to the authority which says you have to look at the context. And of course, the context of joint enterprise is set out, and I will take you to this in Core Volume 1. Core Volume 1, tab 11, page 451.
Sorry, what was the page?
Page 451, A451 in the core volume.
Yeah.
Now, I bring this to your attention with the précis that the Justice Committee have said in very clear terms that the statistics on joint enterprise are insufficient to found proper policy decisions, that the data is simply not captured. But you do have before you some pretty good data from a University of Cambridge study. And this is a summary of that study, which says, and I will summarise, but I do recommend you read it, from the bottom paragraph of page 451. So this was a study of a few hundred prisoners at a particular prison. And 54% of the sample said they'd been convicted under joint enterprise. And if you look over the page, of that group, 19% said they were aged 18 or under when sentenced, so 19% were children. 43% stated they were aged 19 to 21 when sentenced, and 38% stated they were aged 22 to 25 when sentenced. So it seems from that sample that all of the people convicted under joint, or said they were convicted under joint enterprise, were under the age of 20, were 25 or under.
That's because that's the study group, wasn't it?
Yes.
25 establishments overall. Young offender institutions, high security prisoners.
Yes, and I apologise, but
It wasn't only
the
one.
point is they were particular. Some under quite a significant number were particularly young.
Yeah, but
also-
people they were surveying were those under 25 at time of conviction.
It's a study of those under 25. Look at the first paragraph.
And also anecdotally, the evidence is that that it's groups of young people who tend to be convicted under these laws, and that seems to be the case. And amongst that group, 75% of the men didn't think that they were guilty. So 74%, sorry, under joint. So that's towards the bottom of
Yes, we see
of
that.
the
Almost
page.
3/4. Yep.
And that's compared to 43% of male respondents and 71% who were not convicted under joint enterprise.
Yes.
So the point I'm making to sum up,
1%.
and I do recommend
Difference is rather marked between men and women. Yep. Anyway, never mind.
the Just for Kids law submissions deal with, in quite
Yes.
reasonable detail, the vulnerabilities of young people, the fact that they're going to be cognitively, it's going to be more difficult for them to understand
Yes.
particular offences, and also the fact that we know generally they need to have a very clear and foreseeable understanding of the criminal law, whereas in parasitic accessorial liability cases, the opposite is true. And the expansiveness of the doctrine, the difficulty to understand it, leads to, and the context of the particularly young people, particularly groups of disadvantaged youths, leads to, in my submission, a breach of the principle of legality. And the second point I make, and I have to stop, is in relation to policy. Both respondents refer to policy in some detail. I can give you paragraph references from both Jogee and Ruddock.
Yeah.
In Jogee, it's 46, 53 to 54, 70 and 75.
Yeah.
And Ruddock is 71 to 74,
Yep.
and 116 to 129. And in fact, in parallel English, Lord Steyn at page 14, E to H, and Lord Hutton at page 25, F to H, both use policy in a very curious way to justify a departure from logic, which is, in my submission, a remarkable approach. But in any event, my simple submission on this is that the respondents have majored on policy but have provided no evidence that despite this concept being around for decades, that it's ever worked to hold back gang violence or group violence.
Right.
Thank you.
It's 1 o'clock now. I think probably realistically, how long are you going to be?
My Lords, I have 3 lines on the law and a short submission on Jogee's case itself that I'd invite you to hear.
I'm not going to stop you. Would you prefer to do it now or prefer to do it at 2?
I'd prefer to do it now if I may. I don't want to inconvenience the court, but I feel Mr Knowles ought to have this afternoon. Thank you very much.
Make it shortly now.
I will. We submit that where the law went wrong was by focusing on possibilities. If we focus on what is agreed, common purpose, or known or believed, simple basic accessorial liability, would be done in those circumstances, frankly, even youths would understand.
Yep.
In relation to Mr Jogee's case, my Lords, you can decide Mr Jogee's case without ever addressing parasitic accessorial liability.
Yep. Understand.
There was no plan, no common purpose.
Understand.
The Crown relied on shanking evidence that Jogee had said he would shank someone certainly earlier on in the evening. That's not Hersey.
Well, you've set this all out in your...
Yes, the evidence was he was talked down by Hersey.
Okay.
The time apart, the text message and so on,
yeah,
yes.
we have that. As well too,
this was not a parasitic accessorial liability case. There was no crime A. To do something is not enough. At most, they returned to the House contemplating an argument. It might be a basic accessorial liability case, but that was not specified, and in any event, there was no evidence. He didn't know of the knife, he didn't take hold of Fife, he did no acts to demonstrate an intention to assist. The unspecified egging is simply not enough. The jury should have been directed in the 3-stage test that I've drawn your attention to. What was Hersey's offence? Did Jogee have knowledge of the knife and that Hersey would use it? Was he acting intending to assist or encourage that offence, murder, manslaughter or affray? Answer to all 3, no.
Yep.
If we ask what Mr Jogee knew or must have known, the most is that an argument or an unspecified scuffle, not an assault, not a stabbing, not a murder. And it's for those reasons that we submit there is no case to answer as a principal nor as an accessory, and his conviction should be quashed with no retrial. Thank you.
Considering we came in a couple of minutes late, I think your time limit. Thank you very much. Well, we'll resume again at 2 o'clock. Thank you. Court's now adjourned.